Hello and welcome to the Mitchell Law Tea Break. I'm Catrin Mitchell and I'm joined by my colleague Catrin Jennett. Today we're going to talk about whistleblowing, which is a relatively recent phenomenon, but one that we're seeing more and more of, whether threatened or brought as a claim in the Employment Tribunal.
That's the big subject, Catherine.
Yes, it is, and it can be quite technical, so we're going to go back to brass tacks to explain where it all started, what it means for employers, and how to handle an employee who says they want to blow the whistle.
Okay, so where did it all begin? Are we going back in time?
Yes, back to the 80s at least. You may remember the Herald of Free Enterprise, a ferry which sank between Dover and Zeebrugge in 1987 following a series of safety failings. And this was one of a number of health and safety disasters and financial scandals which were found to have been preventable if only the organisation had listened to staff who could see what was going wrong. And there was a growing recognition that staff who were prepared to put their heads above the parapet and call out wrongdoing or dangerous practices should be protected from reprisal.
So whistleblowing started life as a movement for the greater good.
It did, that was what was always intended.
That's where the Public Interest Disclosure Act came in.
Yes, it was introduced in 1998 and it's still with us. Colloquially, we call it whistleblowing, but its proper name is Public Interest Disclosure, which I'd prefer us to stick to, as I think it would help flush out some of the misuse of the provision which we see these days.
Why do you say misuse? If the purpose is to protect whistleblowing workers from suffering a detriment, how could it be misused?
Well, it started life as needing to be in the public interest, but nearly 20 years after its introduction, in the way of these things, people have found ways to stretch the original intention of the law. And perhaps one of the most extreme examples of this, an estate agent used such a claim to pursue a payment of commission which he said he was owed following a manipulation of company accounts. And he argued that this was in the public interest, as a group of his colleagues, also estate agents, were similarly affected. I make no comment.
So some of these uses of the law seem quite cynical. What you're describing doesn't feel consistent with the original purpose of the law. Should we go back to basics?
It's a good idea.
So, in order for a worker, and remember it's not just employees who are protected, to be protected from detriment, they have to make a qualifying disclosure.
So what are the hoops they need to jump through to show that?
Well, firstly, they actually have to make a disclosure, not just threaten to make one or just gather evidence.
Yes, and we see that quite a bit, don't we? Employees stating that they're going to blow the whistle when they mean they just want to make a complaint. This company is immoral.
Yes, just saying that isn't going to be enough. In order for it to qualify as a disclosure, rather than a moan, it needs to relate to one of the 6 types of relevant failure,
Which are?
criminal offences, breach of a legal obligation,
Which is what the estate agent was complaining about?
precisely, miscarriage of justice, danger to the health and safety of an individual, damage to the environment, or the deliberate concealing of information about any of the above.
It's quite wide then.
Yes, and necessarily so to ensure that genuine whistleblowers are covered.
And you say genuine, surely someone who isn't concerned about a miscarriage of justice or a criminal offence wouldn't have protection?
Good question. The Act requires that the whistleblower has a reasonable belief that the information they are providing does show one of those 6 failures. They also have to show that they reasonably believe the disclosure was in the public interest. So pure self-interest will not be enough to get over the line. But again, it can go quite wide, and some would question whether it's right that an ex-employee who is primarily motivated by revenge or self-interest should still get the protection which they can if they find some way of showing that they genuinely believed it was in the public interest as well. Basically, public interest does not need to be the motive, but must simply be a reasonably held belief.
That's a bit confusing. Where's the distinction?
It's a fine line. For example, in one case, a compliance officer who raised concerns about compliance issues purely out of concern for her own potential liability was held not to have satisfied the public interest test. But in the case of the estate agent, the disclosure was still held to be in the public interest as it affected his colleagues, even though it was highly likely that his primary motive had been securing his own commission.
So once they've showed that it's one of 6 failures and that they reasonably believe it's in the public interest, they're over the line.
Not quite. The disclosure has to be a protected disclosure. This is about who they tell. What the Act doesn't encourage is for you to go straight to the papers or social media. This is the one worth taking note of. If your organisation has a whistleblowing policy, you can reasonably expect that an employee wanting to make a disclosure should make that their first port of call and contact the individuals named in the policy. A policy might also make provision for a named other third party to be used. Those wider disclosures, such as to the police or to the media, will only qualify in very limited cases. However, as qualifying disclosures made to the employer count, it is likely that simply telling somebody more senior than you may constitute a protected disclosure, even if they are not the official whistleblowing contact.
So is there enough for a claim once an employee has shown that they've made a protected disclosure?
No, they have to show that they've suffered a detriment as a result. And for the tribunal, it has to believe that the reason for the detriment was the fact that they blew the whistle.
Interesting debates on that point.
Yes, people can get hung up on 1, was there a disclosure? Or 2, was there a detriment? But you have to show that there was both. And then the tribunal needs to believe that the detriment was because of the disclosure. If the detriment was caused by something else, the whistleblowing claim isn't going to succeed.
Yeah. So an example, an employee tells their manager that there's been health and safety failing on the factory floor, but he does it while shouting and swearing and then storming off the premises. The employee is called to a disciplinary hearing as a result and given a final written warning for the manner in which he raised the matter. So he's raised a protected disclosure and suffered a detriment, but if the employer can show that the reasons for his action was his behaviour rather than the disclosure itself, his claim won't succeed.
So the best advice for an employer who wants a fair chance of being able to defend a claim from a whistleblower is to have a policy?
Yes, because that gives a genuine employee a pathway to raise a concern, and it's a helpful defence when defending a claim for an employee who says they're a whistleblower but didn't actually follow the process.
So if an employee can show they suffered a detriment as a result of blowing the whistle, what sort of compensation could they get if they raised a claim?
Well, as always, it depends. And if the detriment complained of is dismissal, effectively that turns into an unfair dismissal claim, with the added benefit that the employee doesn't need the usual 2 years of qualifying service. So perhaps relevant that some ex-employees who don't have 2 years service sometimes later recall having made some kind of disclosure. An additional challenge is that the usual limits on compensation don't apply to a whistleblowing unfair dismissal.
That's worrying for employers. What about where there hasn't been a dismissal, but another detriment, say being given a formal warning or blocked from promotion?
Well, again, damages are uncapped and they will be approached in a similar way to damages for discrimination, which may include an award for injury to feelings.
So plenty for employers to think about. Any final points?
Yes, just one. The old NDA again. It's sometimes tempting to move into settlement discussions when working relationships have seriously deteriorated. But if there have been murmurings at any point from the employee about whistleblowing, even if mischievous, it makes sense to flush those out, investigate them and resolve them before moving into settlement discussions. There's obviously been a lot of noise about the use of NDAs to hush up scandal, and it's worth bearing in mind that any agreement which sets out to cover up a protected disclosure will be invalid.
Well, that's good to know. Well, that's all we have time for this time. Thanks for joining us, and we look forward to seeing you at another Tea Break session.
Thank you.